Hello, my name is Yvette Betancourt. I'm a licensed title agent and registered paralegal with the state of Florida, working for the closing company Title and Escrow. In September of 2014, the Florida Association of Realtors and the Florida Bar prepared a revision to the often used FAR Bar As-Is contract. We've identified some working problems with this contract and can offer up some easy solutions for buyers and/or their realtors when preparing this contract. The first problem affects both buyers and sellers. By default, and if left blank, the title work is due within 5 days of closing on this contract. If title issues do surface in the title report, this does not allow sufficient time for the sellers to resolve these issues. The solution is simple. Buyers can pencil in that the title work is due 21 days to 30 days before closing. If issues surface, the seller has an ability to resolve them or let the buyer know that they cannot resolve them. The second problem affects both buyers and sellers. By default, it states that the survey is to be completed 5 days before closing. Again, if surveys issues arise, that does not allow the seller sufficient time to work on them. The solution again is simple. An additional terms section requires the survey to be completed within 21 days after effective date. That's neither too soon nor too late to identify survey issues. The third problem affects the buyers. The inspection period in this contract includes the search for code violations and open permits. Municipalities can often take 10 to 14 business days to prepare this report, and these reports often arrive after the expiration of the inspection period. In essence, what this means is that sellers have no obligation to resolve these issues, and buyers are often left holding the problems that can amount to tens if not thousands of dollars in code violations and open permits. The solution to that is, in the additional terms section of the contract, require the seller to close out any open permit or code violations before closing. This write-in language in the contract will override any boilerplate language. The fourth problem affects realtors. There is no clearly marked line for the realtor commission, even though the MLS agreement and the listing agreement define those commissions. It can often be avoided that sellers and their listing agents have to discuss these terms right before the closing. The solution is just write in the percentage anywhere in the contract. These few extra steps will make the closing go much smoother when using this contract. For a complimentary contract review, or if you have any questions, please contact us at 305-271-0100 extension 701 or info@theclosingcompany.net.